Good evening, everyone. As you know, you'll soon meet Leon Wiles, renowned for success as an immigration attorney and for his representation of former Beatle John Lennon. Though you may not know, you're sitting in on a class in business immigration taught by Professor Michael Wiles, who practices with his father. I asked Professor Wiles if I could push the doors open and invite Cardozo. Thankfully, he agreed, and the result has been that our class just grew to 3 times its size and includes students, alumni, and attorneys. We founded the Cardozo Student Speaker Series to take advantage of just such opportunities, utilizing connections that students and professors have to fascinating attorneys and professionals so that the Cardozo community can meet, learn from, and form a relationship with them. Past events have included high-caliber speakers who have made global impacts in their fields, such as Dr. Howard Shillett, an internationally renowned forensic accountant, and Ari Bergman, managing principal of the hedge fund Penso Advisors, who frequents Europe and Latin America on business and speaking engagements. The speaker series, OCS, and FIRE have co-funded the food and drinks, and you're welcome to the food throughout this whole talk. And please, there should be 2 sign-in sheets closer to either end of the room. Please make sure that you sign in. I would like to now please welcome Professor Michael Wiles.
Thank you, Asaf, for putting this together, and to your colleagues at FIRE, which is the Immigration Law Society here. Thank you for your diligence. I think this actually is co-sponsored by them and wraps up their series of lectures that they have. I would urge anybody interested in learning about the field to be in touch with that wonderful group, and of course, to look for a professor of your choosing and to take the abundance of classes that this institution offers on immigration. It was actually my first year of teaching last year at Cardozo. This is my second, following my father, who taught for 32 years. And they now offer an abundance of classes and clinics. Business immigration law is now the issue of the day, and it's been my privilege to teach. This is our 11th class, so some of the students will hopefully bear with me and be patient as I try to put things in context for the class. Just a couple of practical matters. There are some of our colleagues in the audience here from our staff in our office, some attorneys and some interested Beatle fans, I think, who wanted to join us. Anybody who is taping this class is welcome to use the materials. If you'd like to follow up in any of the nuances or study this or want some materials, you should also feel free to email or to contact us. For the purpose of the video, my contact email is michael@wildeslaw.com. That's michael@wildeslaw.com. I took the liberty of making 50 copies of Cardozo Life back in the day in 1998. They featured the Lennon story, and it's an endearing story about an extraordinary case and a legend, and the scholarship of the case is what we will be focusing on today. For those of you that regretfully signed up for my class, just a bit of housekeeping news. We will be meeting due to Hurricane Sandy this coming Sunday, I think from 2:20, and that will be our class. I inverted the classes. This is actually the material for the 12th class in the syllabus. It's actually the 11th class we're taking together. As promised, I have a full outline for the entire course. And the following class, after Sundays, I will be doing a review for the final. It would be foolish for you not to attend that class, and for any of your colleagues that aren't here to warn them. Any material not covered in that class will not be on the exam. By the inverse transitive theory, anything covered in that class will be on the exam, and I think you want to be here for that class. So please feel free to collect a journal, a syllabus and an outline that I prepared. That will make your studying a lot easier. And finally, there's a class roster for attendance. Attendance is tracked in this class, and I would ask you to come over if we have a break or at the conclusion of the break, because we're keeping a separate roster. Well, a little background. I graduated from this school, and this is probably my 35th class on John Lennon and immigration. My father started teaching here, Dad, when was it, 1980? 1980. I don't know if everybody in this room was born in 1980, but no doubt the extraordinary lessons of the last 30 years on immigration jurisprudence as hailed from not only this famous case that we're here to discuss, but from a very, very abundant, robust area of law. I met my wife in this class. I have my daughter who's joining us, and a lot more to give to YU and Cardozo Law School than I can imagine. And I'm grateful to this institution for not only what it contributed to the jurisprudence and scholarship of immigration law, but to my personal family as well. Today's class is taking up business immigration law, particularly litigation. It's a different kind of litigation, and if you're fortunate to work in a practice that has a business litigation or a litigation group, you'll find yourself immersed with mostly an administrative area of law, with tentacles and paths to go into the federal court system. Most immigration practices, for those of you that aren't taking the class, are sometimes focused either on business visas, family visas, or litigation. We happen to have a practice ourselves in Midtown in New Jersey that focuses on those areas, plus compliance, consular work, asylum work, and a lot of other things. The removal proceedings and the relief from removal is an ancillary to a business immigration class. And I would urge you, if you haven't taken the general class, to see to it that you do. But today we're going to be talking about the backdrop, and then I'll introduce our very, very respected speaker. There are generally two agencies that you're dealing with in the litigation persona. First is the Department of Homeland Security, and then U.S. Customs and Border Protection. Generally, you'll come into harm's way if there's an investigation or if there's an apprehension, and there are all sorts of systems that are set up in our government for pre-inspections abroad where you can actually meet U.S. immigration officials before you hail on U.S. soil, outside of our territorial bounds, or within our borders. And the authority for our immigration agents to actually conduct arrests and investigations is very robust and broad, and it actually allows them to inspect persons and product and property within 100 miles of borders. Immigration officers can board and search any vehicles, including boats and vessels, and if the examining immigration official determines that you're not clearly authorized to be here and all the principles that we spoke about with regard to dual intent and so forth, you have the option of either withdrawing your request for admission to the United States or departing. Immigration officials have the right to parole people in, so you haven't effected an entry or a departure, or to actually put you in expedited removal if you come in a visa waiver country, a country that we have studied in the past. There are, of course, special circumstances where the government could put in requirements for nationals of certain countries. We saw this post 9/11 with the NSEERS program, where they have security and they required approximately 82,000 non-citizens who registered under this program, for example, who were males of 25 Middle Eastern countries. It's a very, very unilateral approach. The government can designate who they would like to and how they would want to go forward. Litigation starts with a notice to appear. It used to be an order to show cause back in the day. A notice to appear will list the specific requirements and place you in the proceedings, and it sets forth generally the rules of the game and what it is that the government feels that you're removable for. The players in a removal proceeding generally are the immigration judge, the Immigration Service Counsel, and then the counsel for the non-citizen. Removal hearings can be scheduled generally within 10 days of apprehension. Interpreters are presented. The right to counsel is okay, but is not vested with a cost to the government. And ultimately, the person has to designate a country in the event that they're going to be deported that they would like to go to. This is the backdrop of what any professor of immigration law would want students to understand. In the business context, it's very rare that immigration law firms will litigate into the federal courts on the denial of a business visa application. But it is very prevalent for non-immigrant temporary visa holders to be in America to come into harm's way criminally, whether it's because of a DUI or another experience that they'll have a problem. This sets the backdrop for a very special case and lecture today. We studied extraordinary ability cases, the EB1. There are a multiplicity of paths that a person can acquire status in this country, and one of those would have been considered back in the day in the 1970s, I think it was the third preference, which were for aliens of extraordinary ability. The EB1, the employment-based first preference, as we studied, is the ability for a person to apply based on their success, showing sustained level of achievement, shoulders apart, others similarly situated in the arts. In the 1960s, such an individual rose to the top of his field. John Lennon, born in 1940 and sadly felled in 1980, was a gentleman who came to our shores, much like most of the immigrants that came and sought either comfort or success in their professions. He was a man who loved this nation dearly. He was not a man known to our family, and you'll enjoy the personal anecdotes and the journey that this gentleman took and the relationship that developed between his attorney and his practice. But he was introduced to that order to show cause and imperiled in his immigration status because of what was truthfully a political agenda at bay. But there were three players. The players were the non-citizen, Mr. Lennon, the trial attorney, Mr. Shiano, and John Lennon's attorney, Leon Wiles. I'm going to play a little bit of an interview that was taped, and there are three major motion picture productions that I would refer you, particularly in the video, if you wanted to see some more of the substance and the heart of this case. That's the U.S. versus John Lennon, produced by Lionsgate Entertainment, Lennon NYC, which was a PBS production, and The Tomorrow Show with Tom Snyder that I'm going to play about 10 or 15 minutes that will set the tone as to how this case evolved. After that, I'll introduce our speaker and stand down. Give me one moment, please. You just turn it off.
But now, you thought that all you have to do was pay the $100 fine, but then what happened?
Well, I did just pay the fine, you know, and that was the end of it. And it went in the papers, whoopee, and another pop star bites the dust, you know. And then I came over to America and just, with no particular decision, decided that I'd like to live here, you know. I came over for a visit or something, and I would always come in and go and and Yoko had been educated in, she was always going on to me about New York, you know. She finally showed me and walked me around. And I fell in love with it, and we thought, get an apartment instead of staying in a hotel all the time.
Surely.
So the next minute we thought, oh, let's stay, you know, isn't it great? So, and we also have other complications going on. The show isn't long enough for it, about her ex-husband running away with her daughter, and there was 4 cases in Houston, the US Virgin Islands, and we had to keep applying for these visas, and after you bust, it's suggested that you don't apply for 9 months, you know, and people now have problems getting in. Mick Jagger, Stones, lots of musicians, Paul, lots of people they have to sort of do a lot of ritual to get in before they can come and go. So we tried to say, look, we have this big case, we need to come in, and there was always a hassle and a hassle and a hassle, and then they started trying to throw me out.
All right, so we're at the point now where it might be helpful to have Mr. Wiles, your attorney, present, just so that nothing is said that might prejudice.
Well, it's really, in case you have a question that I can't answer, you know, they ask me what's happening with you, and I say, well, there's some paper linked to some senator that's full, and I don't know who.
All right, fine. You were told it might be a good idea to wait for 9 months before applying for citizenship?
No, this was after the bust in England, before applying to visit the United States. That it would be a cool idea. That's sort of, you know, it would be a cool idea.
What is your status in the country right now?
That's why Leon's here. What am I, Leon?
Well, John was charged with being deportable in the United States for being an overstay by a very interesting turn of events. The district director of the New York Immigration Service charged him with being an overstay after he gave him a 2-week extension of his time. And in the middle of that 2-week period,
he was here on visa, right? And he overstayed. Is that the position?
He had originally come in as a visitor, and he had had a number of extensions. And then finally, the Immigration Service gave him a 2-week extension. And right in the midst of that 2-week final extension. They revoked the period that they had given him, and they declared that he had been here as an overstay for the week that he had been here with their authorization. And thus the Immigration Service created the very status that they charged him with being deportable for. We fought that deportation case, and a decision was finally rendered after about a year that he was, in fact, an overstay. Now, the essential problem in the deportation case, and what lies beneath the surface, is that the only way one can get out of it is either to ask permission to leave this country voluntarily and get out, which John was not prepared to do, or to apply for permanent residence status. And the law prescribes that any person who had ever been convicted of any offense, no matter how small, relating to the possession of marijuana, at any time in his lifetime and under any circumstances, cannot obtain residence. And so that what was happening when the government did this little routine of revoking his stay and charging him with being an overstay, they were locking him actually into a position where the only application he could make was one which they were pretty sure he could never succeed in.
Which one?
Pardon?
The application that he would make would be one that he would
For
never
permanent
succeed in.
residence.
Permanent residence.
Yeah.
All right.
And we applied for permanent residence for John and for Yoko. We won Yoko's case, and she was granted residence. But John's case was denied. We went up on appeal before the Board of Immigration Appeals, and we lost there as well. And we are now before the United States Circuit Court of Appeals on the same issue. And basically, on that case, the issue resolves itself into whether or not what happened in England amounts to possession under our law, and whether what he possessed in England was actually marijuana under our law. You see, the substance which John was convicted of possessing, he pleaded guilty, was called cannabis resin. That's a generic term, and it includes a number of substances. We had one of the top experts in the United States, a psychiatrist at Harvard Medical School, testify, and he gave the only expert testimony. And his testimony was that cannabis resin is not marijuana, and marijuana is not cannabis resin. Yet the Immigration Service came to the conclusion that it was marijuana. And finally, with respect to the possession aspect, our law in the United States is very clear with respect to possession. You cannot be convicted in this country for possessing an illicit substance unless it is clear that you had a knowledge as to the illicit nature of the substance that you have. In England, at the time of John's conviction, a law existed which had been uniformly criticized throughout the world, and which was later repealed. And it provided that the government did not have to prove that you knew the nature of the substance whatsoever. So that if you possessed a bottle and you thought it had aspirin in it, and in fact if the aspirin turned out to be some serious drug, you must have pleaded guilty under those circumstances because there was no way out. And that actually was the legal situation that forced John into this, and that's where we stand with respect to the immigration.
I know that this is not a second, excuse me.
I was just going to say, one interesting point was that when they started the initial case, they claimed that it was a local New York problem, and they also started the proceedings against John and Yoko. Well, halfway or a third of the way through the proceedings, or whatever the number is, they discovered that actually Yoko did not have any record in England, and also she had a green card by a previous American husband. So this local case that was just another case like any other alien, which is what they kept claiming, was not one of those cases. So then they suddenly had to find something else, which was this overstay business, which they pulled a fast one. And so they had to give Yoko the green card. And there's, now, one of them, I think his name is Green, keeps writing to the papers saying they're still treating me like a normal citizen, a normal alien, right, only on overstay. They're no longer mentioning about marijuana, and the original normal reason I was being thrown out. And it's just interesting that the case keeps changing to suit them, you know?
I know that this is not a satisfactory question, but maybe you have a satisfactory answer for it. You know, when all of us were little, we were told, why try to be someplace where they tell you that you're not wanted? You know, if you go over to a friend's house and his mother says, hey, I want you around, you can come home. You could live almost anywhere you wanted to in this world. And so, if you're getting hassled, and this does not in any way negate the incorrectness of the hassle, if it is, as your attorney says, why put up with it?
Because I'd like to live in the land of the free, Tom. And also, if it was up to Joe on the street, he either doesn't care about it or would be glad to have an old people living here, you know? Now, if I get in a cab with a cab driver, there's nothing to do with music or anything. He'll ask me, how you doing? I hope you can stay. So your average citizen either doesn't care or wouldn't mind me staying here. I like to be here because this is where the music came from, this is what influenced my whole life and got me where I am today, as it were. And I love the place. I'd like to be here. I've got a lot of friends here. And this is where I want to be, you know. Statue of Liberty, welcome. I even brought my own cat.
Brooklyn Bridge, want to buy it?
No, you're the ones that buy our bridges.
There is another case which we haven't discussed, and that is our case against the government.
Oh, you've got one against them.
That's true.
Yeah.
We've gone to court on 3 separate occasions, but the action that I'm talking about is the Selective Prosecution Act. We had some information that the deportation proceedings against John were not normally brought. Certainly the procedure followed was not normal. And we had learned that rumors got to the Senate Internal Security Committee that John had some idea, or was rumored to have some idea, of appearing at the Republican National Convention in 1972 and leading an anti-Vietnam War demonstration or the like. And that this information in the form of a memorandum was transmitted by Senator Strom Thurmond to the then Attorney General, John Mitchell, who may have at the time been sitting with the other hat as well as head of CREEP, the Committee to
Re-elect
the President.
The former president.
And we understand that a series of memoranda led all the way down to the district director in New York, and that the action he took was not as a result of John's immigration status, but rather as a result or an intention to prevent John from exercising constitutionally protected
What are they afraid of you doing if you have permanent residence here?
I don't know. I think that when it was started, somebody didn't want me here, and now they probably don't mind, you know. It's just it's a bureaucratic thing. It's gone on, and how do we stop it? You know, maybe whoever makes the decision doesn't know whether to be either politically right or what's going to happen if we suddenly stop now when we started. I mean, it's very sort of embarrassing for everyone, I guess. And I don't think half the people that started are now having their own problems, right? So I don't know where I am. I know there's a different lot of people in charge of my case now, and I'm sure they're not as hot to get me out because they didn't even have the Republican convention in San Diego, and I was not permitted to go there either. So,
I only have less than 1 minute left. You know, you've been a very low-key and very mild-mannered guest in this program, yet I've heard you described as being humane. Understanding that, vis-a-vis the way that you read that, why was
because one gets a reputation for one thing or another, whether it's true or false. If being an egomaniac means I believe in what I do and my art or my music, in that respect, you can call me that, you know? I believe in what I do, and I'll say it, you know? And otherwise, this is pretty much me, you know? Apart from being on TV. You know?
Well, you're one of the nicest egomaniacs I've ever met.
Oh, so are you, Tom.
But now, you thought that all you have to do was pay the $100 fine, but then what happened?
Well, I did just pay the fine, you know? And that was the end.
Fascinating to watch it. Whether you're the speaker's son or a student of the law, I can keep watching this. And if you look at I place this on YouTube, the thousands of people that watch it, I'm not alone. Just 2 comments before I introduce our speaker. The deferred action known as DACA, where the DREAM Act couldn't pass to help children by no act of their own who were brought onto the shores, was passed by President Obama, hailed its jurisprudence from the Lennon case. Well after John had gotten his green card, he authorized my father, through the Freedom of Information Act, to see that there were provisions and the ability of individuals to get status on our shores, where the government looked the other way. People who had drugs, guns, all sorts of crimes. John, in many ways, was still working for those that weren't here and had a vision of what the possibility, the potential of this country was for. He lived, in many ways, as a dreamer, and today, literally, answered the dreams of many. And you have to study that law to appreciate it. Just to set the context, my father was approached by somebody to represent John, came home after first meeting him late at night, which was the custom of their meetings, and was embarrassed because he had no idea who the hell John Lennon was. So much so that when he came home to my mother, rest her soul, he turned around and my mother said, "Where were you? Who were these important clients?" And he turned and said, and my mother told me this, it was Jack Lemmon and Hirohito. I have no idea who they were, but they're bigwigs. And my mother said, "Was it John Lennon and Yoko Ono?" "Yeah, that's who they are." "Where were you, Leon, all these years?" Well, just to give you an idea where my father was, a graduate of Yeshiva University, NYU Law School, a former president of the American Immigration Lawyers Association, where there are now 14,000 U.S. immigration lawyers. My father still stands as one of the proud and the few, known for his scholarship, his advocacy, and his extraordinary consideration and compassion for aliens. It's my privilege to announce my professor and my father, Leon Wiles.
That's not easy to follow. I'm in the process of writing a book right now on the Lennon case. It took me about 24 years of writing, or more likely 42 years of writing, and I finally found somebody who knows how to consolidate and capsulize the overwriting of an over-anxious author. So it's taken me a long time, but we're finally getting someplace with the case. The case starts with me with a call from a former classmate from law school. And he says, "Leon, you know, I'm now counsel to Apple Records. I've given up my private practice in your building, and I would like to know if you could come with me to visit these clients." I said, "Visit the clients? Why don't you just have them come here?" He said, "Well, they're kind of heavyweights and they don't just go to lawyers' offices." But since he had never disappointed me in the past, and he had very good connections, I was happy to go. And I went to his office, where I met a fellow named Alan Klein, who was the Beatles manager, and we went in Alan's car to the village, to John and Yoko's apartment. And on the way, I asked Alan, I said, "Who exactly are these people?" He said, "You don't know who John and Yoko are?" I said, "No, not really." He said, "Don't ever admit that publicly." He said, "They are looking for immigration counsel, and I recommended you." But when I got there, I realized that I wasn't the first and only lawyer they had spoken to, because the questions were much too informed and bright. And their apartment on Bank Street in the Village, you step down into a large living room which was loaded with packages, desks, equipment. Seemed to be just a storage room. And then they took me into a room that was a kitchenette. And I was to learn afterwards, in subsequent trips there, that the room beyond that was essentially their living room. It was a bedroom, a large bed with a huge TV that they kept on, colored TV with no sound. And anybody who visited them sat around the bed while they were in bed. That was the social milieu of 150 Bank Street. The first person to introduce herself, who arrived from the back room, was Yoko Ono, a lovely Asian woman, obviously very bright. And she started to tell me her story after we were introduced. She said that she had spent half of her life in the United States as a child growing up here, and she attended Sarah Lawrence College and had been coming back and forth for years. She said that she also had an American husband previously, and she has a serious problem with that former husband, Tony Cox. He has a hang-up. One day when he was visiting their child, Kyoko, who was then 8 years old, he disappeared and never came back. And she's been looking for him ever since. It's been years. She's traveled all over Europe. There would be a rumor that he was in a spot with a child, or that a child who looked somewhat Oriental was with an American or what have you. And they would run all over Europe, and by the time they got there, because they were so important, word would get out that they were there, they would find that Tony Cox and Kyoko had disappeared. She started a custody proceeding in the United States, she explained. The child was never subject to a custody order, but they returned to the jurisdiction where their divorce was granted, and started a custody proceeding for Kyoko there. He disappeared. The judge ordered him to appear, held him in contempt, and he never showed up. She got a temporary order of custody in those circumstances, and then one day he shows up in Harris County, Texas, where he had not lived before, but apparently had some friends. And he started a custody proceeding. John and Yoko go out there and testify and appear in the proceeding, and the court there also gives them temporary custody. And when they're looking for the father and the child, he absconds once again, and that court also held him in contempt. So we're dealing with her with a situation that she's come to the United States to find her child and to get custody or share custody. She was not a jealous mother. she would have been happy to share the custody with her former husband. She also explained to me the nature of her work as an artist. And she was involved in that when this young man, John Lennon, walked into the room from the bedroom. So she held off and introduced him. And he explained his problem. He says that he's a British musician. I didn't ask him any questions about it. I didn't want to appear too stupid. And said that he had been in the United States on numerous occasions, but each time he came, he needed to get a waiver, a special waiver, of his eligibility to come as a visitor. And he would have to apply for that at the American Embassy in London. And there was a lot to do, a lot of documents and lawyers working on these things. And finally, they would allow him in. And sometimes the U.S. government got upset with them because if he came and said he needed to stay here for 2 months and only stayed for 2 weeks, they thought he was not appreciative. And if he came and said he wanted to stay for a month and needed to stay for 3 months, they thought he was asking for too much. So it was not an easy situation for him. I asked him about the conviction, and he showed me a document, a conviction of a British court that for possession of cannabis resin. Now, I didn't know anything about the Beatles. I certainly didn't know much about marijuana. And I asked him, what is cannabis resin? Is it marijuana? Now, the question was an important one because the Immigration Act at the time made excludable a person who was convicted of a narcotics offense or possession of marijuana. Originally, it only said narcotics, but a clever lawyer in California argued that marijuana is not a narcotic. It happens to be a hallucinogen. And he won his case. And immediately, Congress added the words, or marijuana, without a definition. He explained to me that he felt this was a terrible imposition on him. He couldn't just visit like other people could. And so my question was, this cannabis resin, is it marijuana? Oh, he said, it's much better than marijuana. It's hash. My education was beginning at the time. It's hash, he said. And acting like a teacher at a blackboard, he would say, well, there is a certain type of plant, and the marijuana is from the leaves, is made from the leaves, and the hash, the cannabis resin, is from the stalks. So I had my first introduction, and I asked him, how did you come to be convicted of possession? I don't know why I asked that question. He said, well, actually, I didn't have any drugs in my possession. But we knew that there was a Detective Sergeant Pilcher in the Scotland Yard drug group who was in charge, and he was convinced that young people and drugs were corrupting the youth of England. And he made it his purpose in life to go out and arrest people who were influential among young people. And he said that's how they got Mick and George. I was supposed to know who Nick and George was. I didn't even know who John was. And he said that in actuality, we had cleaned out the apartment very well, and we were on a macrobiotic diet. We weren't going to have any drugs around. And there he comes, Detective Sergeant Pilcher, and the dogs and the drugs, he says. And I was charged with possession of the cannabis resin and with resisting arrest. He said, resisting arrest, you can understand that. He says, that's trying to get your trousers on and get dressed before they break down the door. He didn't, I asked him a question. I said, what about if you didn't have it in your apartment? How did you get convicted? He said, well, I pled guilty. And my lawyer advised me that I had to plead guilty. I'm learning as I go along, and it puzzled me why a lawyer, and I'm sure that he could have had the best, would advise him that he had to plead guilty if it was never in his apartment, and he had actually cleaned out the apartment and so on. He's telling me his story after she told me hers. And then she says, what can you do for us? Well, I said, it seems to me that what you need is time in the United States. And if all you need is time, I'd say that the lawyer who brought me here is perfectly capable of applying for an extension of visitor's status. And you can get, in my opinion, immediately a 6-month extension. It seemed like the reason that they needed an extension, looking for a child and trying to get custody of your child, was probably the strongest reason I could imagine for an extension of stay for a visitor. Then she said, how would you go about trying to do more for us? I said, well, you could try to get residence. What I would do, I would say, is file for each of you in the third preference category at the time, it's now first preference, as an extraordinary person in the arts or sciences whose presence in the United States would be beneficial to the American economy or the American culture. And she said, is there any way of getting by John's ineligibility for a visa? We were told, she said, that led me to believe that there were other lawyers who they spoke to before. She said that he's never going to be eligible for residence in the United States, that it's waivable for temporary visas, but it is not waivable for permanent residence. Well, I said, there are several things that he's told me that I would want to check into. First of all, I said, the statute, and I had a copy of the statute with me and showed it to them. The statute talks only about narcotic drugs or marijuana. And if this is not marijuana, even if it's more serious, then Congress left it out. And that can be challenged. Second, I thought, and there's an issue here that I don't understand. A lawyer worth his salt, and they could afford the saltiest, in England, tells him that he had to plead guilty, which I don't understand because he wasn't guilty. I'd need to study the British law and see if there's something about it where the conviction should not be recognized in the United States. Perhaps it might be considered a denial of due process here to accept that kind of conviction. Another thing that John had mentioned to me was that the British Parliament had 4 years earlier, at the time of his conviction, passed a law that said, it was called the British Rehabilitation of Offenders Act, that if you have any conviction and it is not repeated within the next 5 years, it will be erased from your record, and it is even considered to be illegal for somebody to claim that you had such a conviction. I said that the Uniform Rehabilitation of Offenders Act is an interesting thing. I don't think it would work in our system here, but I've never heard of it before, and it's never been challenged here before, and it's probably worth a lot of time if we wanted to challenge it. Once the next year passes, and he's been here, he's lived for 5 years and not had a further conviction of the drug. But I said, as far as your case is concerned, if all you really need is an extension, you really don't need me. I think that Alan Kahn, his name was, Alan Kahn would be capable of doing that, and I'd be happy to look at his papers if he asks me to. And then this happened a number of times in dealing with John and Yoko, but it was the first time they said simultaneously, "We need you." And that's when I knew that I was being retained to represent. I returned to my office, and I was retained, and we started working on these third preference applications. Well, let me tell you, I've never seen reference letters like this. They came in fast and furious. Anybody we wanted. Andy Warhol, Clive Barnes, Jasper Johns, Stanley Kubrick, Elia Kazan, Kleist Oldenburg, Leonard Bernstein, Virgil Thompson, all the experts and professionals were happy to give letters of reference to John as a musician and Yoko as an artist in her field. I happened to work on hers myself because I couldn't get many of the members of my staff to do hers because it was not an easily understandable art. His was readily understandable, and I had never done a third preference with such impressive references. The first thing I did while working on these was to call on my old friend Saul Marks. He was the district director of immigration in New York. And to give a 6-month extension was nothing for him. I called and asked him, and I said, just to make sure I got in to see him, I said, because it's a waiver case, I think you may need to check with Washington to renew the waiver as well. And if it's okay, I'll come in and talk to you about it. And when I came in, I was shocked. He said, first of all, they're in my jurisdiction. How come I don't know about it? I never thought that the district director of immigration has to know any time a musician comes into his jurisdiction. He said, I'll have to check with Washington and I'll get back with you. He called me the next day and he said, Leon, because it's you, I'm giving you a month. They are not entitled to, they will not get an extension, and get them the hell out. Now, I'd known the district director for 20 years, I don't know, and I got along with him very well. And I said, what's the problem? He said, the atmosphere in Washington is not conducive to having them stay here. And if you're smart, he said, you'll get them out because whatever you do will not work for them. I filed my third preference. Well, I filed the extension asking for a month and got it. So that I was given the month of February. They had previously had until the end of January. And I filed the petition for third preference, the two petitions, on the 3rd of March. On the 6th of March, they had already received a letter granting them permission to stay until the end of February. And then there was a letter written for you may leave by March 15th, and please let us know immediately as to how and when you'll be leaving. March 3rd, I filed these applications, and March 6th, the only time in my professional career, and I'm practicing immigration law for over 50 years, I'm served personally with an order to show cause. Now, I'm not an alien. Usually, they serve the alien. I'm served with a copy of it, and my clients are served at their village apartment as well. On the 7th, I'm served again. The first one is to charge them with being overstays. The second one was to charge them as overstays and also being here in violation of status. I didn't know what that meant. And the hearing was scheduled for March 16th. I took them to immigration at that time. They were very nervous. They didn't know what to wear. They had, in England, they managed to get through this, where he only stood at the dock and she was released from because he said that he accepted guilt in the case, and so they discharged her. They were so nervous that I decided to call the chief trial attorney to whom it was assigned in New York, Vinnie Shiano, an old friend of mine. And I said, if you wouldn't mind, I'd like to come up early. They're very nervous about appearing before an immigration judge. And because he was a real Lennon fan, Beatles fan from way back, I said, make them feel at home, and then we'll go into the hearing. So we appeared there an hour early, and they are talking about music for most of that hour. And then all of a sudden, Vinnie Shiano whispers to me, Leon, he says, I don't think they realize that I'm the prosecuting lawyer. So I said, John, Yoko, I hope you feel more at ease now. We're going into the immigration judge's courtroom. Vinnie here is the prosecuting lawyer. So you can understand that these are nice people. John took a handkerchief from his pocket, got down on the floor and started shining Veneziano's shoes. Looked at him and said, "Can I do anything else for you, Mr. Sciano?" And with that, we went into the hearing. The hearing was on the 16th. It was adjourned to the 18th. After the 18th, after the hearing, we went up to the office of the manager of the former manager of the Beacons. He has one of these super impressive offices with a huge glass wall behind his desk. And we're talking, Geraldo Rivera came along. He was one of our witnesses. And we were talking there as seated against a table like this with a glass wall behind it. I noticed that two window washers are rising on on a cable. They're moving up. And Lennon sees them. We're talking about the government, President Nixon's action, and the Attorney General, John Mitchell's activity in the case. And he stands up all of a sudden, raises his hand and says, "I'm sorry, Mr. Mitchell, I didn't mean a word of it," as he sees these guys moving up. What actually happened is a little history. 1971 is when they arrived in the United States, and the re-election of Richard Nixon was to take place in 1972. So that there was a lot of activities. You guys are mostly too young to remember the dirty tricks of Richard Nixon and his group. But Nixon actually ended up being reelected and then had to resign because he would have been impeached otherwise. We didn't know about it at the time, but I'm going to read something to you that was in the district director's file at the time. A letter dated February 4th, 1972, signed by Senator Strom Thurmond on his letterhead, attaching a memorandum to him from the staff of the Internal Security Subcommittee of the Judiciary Committee of the Senate. Now, I thought that that subcommittee went out with the Russian scare in the 1950s. He says, "I'm a member of the subcommittee and the full Judiciary Committee. This appears to me to be an important matter. I think it would be well for it to be considered at the highest level." Now he's writing to the Attorney General of the United States. There is only one guy higher than the Attorney General, a member of the President's cabinet in Washington. He says, "As I can see, many headaches might be avoided if appropriate action be taken in time." He was suggesting deportation. What was the memo? The memo of his subcommittee says John Lennon, presently visiting the United States as a British citizen, a member of the former musical group, etc., etc. Lennon and his wife appeared for about 10 minutes at 3 a.m. on December 11, 1971, at a rally held in Ann Arbor, Michigan, to protest the continuing imprisonment of John Sinclair, a radical poet. That rally was called 10 for 2, and it was called to try to get him out of jail because he was sentenced to 10 years imprisonment for possessing 2 marijuana cigarettes. They go on to explain radical New Left leaders, Rennie Davis, Jerry Rubin, Leslie Bacon, Stu Alpert, Jay Craven, and others, have recently gone to the New York City area. This group have been strong advocates of the program to, quote, dump Nixon. They have devised a plan to hold rock concerts in various primary election states for the following purposes: to obtain access to college campuses, as though that's an illegal activity, to stimulate 18-year-old registration. Now, we also have to know historically this was the first time in 1972 that 18 to 21-year-olds can vote. Before that, you had to be 21. Now, of course, Richard Nixon is sending 18 to 21-year-olds to Vietnam. And John Lennon apparently doesn't agree with that. So they decide, according to a confidential source, usually that means illegal wiretap, whose information has proved reliable in the past, the activities of this group will follow the pattern of the rally mentioned above with respect to John Sinclair. David Sinclair, the brother of John, will be the road manager for the RockCon festivals. Davis and his cohorts intend to use John Lennon as a drawing card to promote the success of the rock festivals and rallies. The source feels that they will pour tremendous amounts of money into the coffers of the New Left and can only inevitably lead to a clash. The source felt that if Lennon's visa is terminated, it would be a strategy countermeasure. The source also noted the caution which must be taken with regard to the possible alienation of the so-called 18-year-old vote if Lennon is expelled from the country. Okay? This goes to the Attorney General's office. It took me 3 years to have it disclosed to me in federal court. The next document that was disclosed to me in federal court is dated March 2, 1972. That's the day before we filed the third preference petition. And it's signed by Saul Marks, my old friend, District Director of Immigration, about both cases. Associate Commissioner of Immigration, Green, telephonically advised me today that we should immediately revoke the voluntary departure granted to John Lennon and his wife. An order to show cause should be issued for both aliens and served upon them with a return date of March 16, 72. Washington is telling him not only to start a proceeding and cancel their stay, but the day of the hearing. I've never seen that happen before. That's strictly a local issue. Mr. Green further stated that under no circumstances should this office approve the I-140 petition filed by Lennon. This is a direction of Commissioner Farrell personally. Further action on the petition will therefore not be taken unless cleared by the undersigned with Mr. Green. Mr. Spivak, he was the person in charge of immigration applications, has been advised. So the plot thickens. We don't know about any of this when I go up and I'm given my 1-month extension and I'm filing my third preference applications. But 2 months pass. I'm trying hard to get the deportation proceedings terminated, and so I don't want to enter into them too completely in various adjourned dates. It sounded to me that I felt that if I didn't have the third preference applications approved, I had no basis for applying for adjustment of status for my client. And so it was quite possible that immigration would just scupple the applications, hide them, whatever, and not adjudicate them. And they would get the Lennons out of the United States through deportation or otherwise without ever adjudicating those applications. I didn't know that was the plan of the Commissioner of Immigration and the District Director in New York to do exactly that. I went to visit Saul Marks again, and I explained to him I need the approval of those petitions. Well, he says they're under consideration. I said, what does that mean? I called the Labor Department, where you would have had to send them for an advisory opinion. And believe me, I knew everybody over there. If those applications were sent there for their opinion, I would have heard about it. Well, they said, I can't tell you more. They're under consideration. I said, if that's the case, we have to go to court. I went back to my office and drew up papers for an action in mandamus, demanding that the district director adjudicate the application. And because I had heard from John and Yoko and their friends and surmised that there might be something like this in the file, where the government was out to hurt them, I decided that I had to see the files that immigration had, and under the Freedom of Information Act, I had the right to do that immediately because I was filing papers with the court. I went down to immigration. I asked that I wanted to see all the applications ever filed by John and Yoko. They produced everything that I knew of, except the third preference applications. You know, I'm a kind of mild-mannered person, but I know how to make noises as a lawyer, and so I started making noises as a lawyer, saying I'm not going to leave this building until I see the file on the third preference. And after 10 minutes, somebody brings out a sealed manila envelope, which I opened, and inside are my 2 third preference applications. No question in my mind they're approvable. And never touched by human hands. I overheard as well somebody saying to someone else, the clerks that they were sending files with, something about Mr. Spivak's safe. And I surmised that these applications had been locked up in the safe of the officer in charge of applications. Then I knew I had to go to court. And in going to court, I swore out affidavits on information and belief that there was a conspiracy in Washington to start proceedings and remove these people from the United States, not based upon their legal situation, but based upon political things and things that are protected by the United States Constitution. I figured I'll at least get opposing affidavits and they'll tell me what the facts are. On the return date, I appear, no affidavits in opposition, and the judge calls me and the U.S. attorney forward and says, we received a call from Mr. Marks at the Immigration Service, where you're a defendant in this action, and he said that they'll adjudicate the application today. Now that was the 2nd of May, already into May, and the 2nd of May was the day of the adjourned hearing. I brought this action in court on May 1st, and the judge couldn't decide it, and they had to wait overnight. And I said, Judge, I'd like you to keep the case open until we actually get written decisions in this case, because I know what to do with a written decision that's an approval or a denial. What I can't take is sitting around for months without a decision at all. The judge said, then understand my position. He said, I can't tell him whether to approve or deny the application. He's got the discretion to do that. But I'll wait for the decision, and when you get written decisions, you come back and we will proceed with the case. Both applications were approved the next day. So I'm breathing a sigh of relief. At least I'll be able to make a bona fide application for permanent residence for these people for adjustment of status based upon the approval of these third preference applications. In the meantime, things are going on in London. Detective Sergeant Pilcher is under investigation. What's the charge? Perverting the course of justice. That means whatever he did to Lennon, he had been doing to others. And as a result, he was arrested. He had run to Australia. Lennon told me that that's where the British go when they want to get away from the law in England. And he was arrested and brought back, and he is now being held in jail. I immediately dispatched word to England. I wanted him visited in jail and to see whether we could get any cooperation. And of course, he wasn't going to talk to us, and he wasn't going to admit anything, because that would be tantamount to saying that he'd been doing this for years. My first witness is Dr. Lester Grinspoon, a professor at Harvard Medical School who wrote the definitive text on immigration, on marijuana. He was the world's expert on marijuana. I had called him, and he told me, he said, look, your thesis is right. There are two different things, and if I were testifying, I would say that cannabis resin is not marijuana, and marijuana is not cannabis resin. But he said, I don't testify anymore. He was an old timer. I couldn't find, I called Alan Dershowitz of Harvard, and this was the top expert that he referred me to. The next day I get a call from Dr. Brinspoon. He said, listen, can I reconsider? He said, I have a personal problem myself. He said, I have a son who is in a terminal cancer situation, and I didn't realize it until I spoke to my wife and my sons at dinner that Lennon is his idol. So he said, if you can give me as much stuff as you can get autographed by Lennon, he said, I'll come to testify. He was my first witness, and he performed beautifully, and he was the only witness to talk about the meaning of the word marijuana. There was no other evidence. The government just assumed, as they always did, that whatever was done in previous cases would be done by the immigration judge here, and that's exactly what happened. It took almost a year for the judge to reach a decision in the case. And when I heard that there was a decision, they didn't tell me what the decision was. Saul Marks, my old buddy, calls me and says, I'm having a press conference. He's with the Immigration Service for 38 years. He's a real enforcement guy. He never had a press conference. He wouldn't know what to do with one. And he decided that he's going public in this press conference. And he said that the decision will be handed out at the time to the press. This, I figured, was my opportunity. I learned in dealing with Lennon over that year that there were a lot of small publications that nobody in normal life, I thought I was normal at the time, ever read. Zoo World, what have you. I called the Lennons and I said, look, do your friends in these publications have ID to come into press conferences? And they produced about 10 such people. And I gave each one a question to ask. When we got to Marx's press conference, he explained that the decision was just given out. Of course, he and my opponent had already read it. It was 47 pages long, granting residence to Yoko and denying residence to Lennon. And that's what I was looking for in the case. I felt that would give me a leg up in the case. I said, if both people get third preference approvals, one is granted residence and the other one is ordered deported, then there's something wrong with the immigration system in the United States, which is supposed to unite families, especially where there's an American child involved. You can imagine the questions I planted in there for Saul Marks to answer. And he answered, he lied through his teeth and said he had no authority to make exceptions, that he's an enforcement officer, and anybody who is an overstay by even a day, he has an obligation to remove from the United States. The Board of Immigration Appeals affirmed the decision of the immigration judge and gave him the same 60 days to leave. We didn't appeal her decision. The the next appeal, it skips the district court, goes straight to the U.S. Court of Appeals. I argued before the Board of Immigration Appeals. The entire board of 9 members sat to hear the argument, which never happens. And they still held against us. I felt that the only headway I had really making in the case was the time I went to the district court to get an injunction against the deportation proceeding so that the third preferences could be adjudicated. I decided then that I wasn't going to wait for the decision of the Court of Appeals, and I was going to bring an action in the district court. Now, I had to actually bring 2 actions because the people I had to sue in the government were different. Action number 1 was an action under the Freedom of Information Act. We all knew that there were people floating around the United States who were totally illegal and had not been removed. And nobody ever explained what it was. We thought that there was a non-priority system where they just put the file on the bottom of the pile and never get to it. And so I sued, asking for an explanation of the non-priority system. I had an ongoing correspondence with immigration on that for years before I saw Lennon. The second action was for a violation of the constitutional rights of my clients, for the illegal surveillance and wiretaps, for the fact that all the applications were being adjudicated unless we dragged the government to court, and so on. And what the government did was they allowed me to examine the Saul marks before trial. Green, his superior in Washington in the commissioner's office, and I got to see the United States attorney had to turn those documents that I read to you over to me. What the court did was, it said there is apparently such a procedure. There are so many people here, and the court ordered that the government supply me with a copy of the files that they had approved under this non-priority classification. 1,863 applications were delivered to my office, and I wrote 3 law review articles analyzing them because Lennon wanted me to let people know that that the government does have prosecutorial discretion and that something can be done for them. The United States Court of Appeals finally rules in the case, but not before the United States Attorney in New York writes to the judge, sending me a copy, saying that without agreeing that immigration did anything wrong, he would like the Immigration Service to consider the non-priority case of John and Yoko, and that nobody who had touched the case before should look at it. 2 weeks before we won in the Court of Appeals, the Immigration Service granted him non-priority status. That's this deferred action status. And then the decision comes down granting residence to John Lennon. I'm going to read one sentence from the decision, which I think is unique. The Chief Judge is writing, "If in our 200 years of independence we have in some measure realized our ideals, it is in large part because we have always found a place for those committed to the spirit of liberty and willing to help implement it. Lennon's 4-year battle to remain in our country is testimony to his faith in the American dream. When that case, when that decision was rendered, I got a call from the Court of Appeals, and the clerk there said, look, I'm not supposed to do this, but if you'd like to get a copy of the decision, it's a 2-to-1 decision and you've won your case. I called Lennon and I said, I'm getting a copy of the decision, we won the case. He said, what do you mean we won? I said, what I didn't promise you, what I told you that I hoped for, we won. We won on the ground that we discussed the first time I met you, and that was that the plea of guilty was improper, that you didn't have to plead guilty, you didn't have what we call mens rea, the knowledge to acknowledge that you had committed a crime. He said, I'm running over to New York Hospital now. Yoko is going to give birth tonight. The next day was his birthday. And he said, stay at your desk. Yoko will call you when you get there. He needed Yoko to explain these things to him. She was like my co-pilot in handling this case. And she said, why don't you and Ruth, my late wife, come over and we'll read the decision together. We did that until my wife told me that Yoko would give us about 2 hours reading, and Yoko was feeling uncomfortable. She was going to give birth that night. And so we told John, call us as soon as there's news, and we left. In the middle of the night, John Lennon calls and says, it's John calling. I was blurry. I said, John who? He said, John Lennon, and I have a beautiful boy. What a birthday. His birthday, his child's birthday, and he won his case. An extraordinary, I've left out huge parts of it, which I'm sure you can recognize, but you'll have to read the book. Thank you.
The life that transpired during the 70s was one where a friendship unfolded, a tremendous one. The FBI was following John Lennon and taping conversations with my father. My father purposefully was saying to my grandfather in Yiddish, thinking that it would be in the greatest spirit to have them hire somebody who could translate it. And he would purposefully mention John Lennon's name and then go up into Yiddish and read transcripts of the conversation. What happened was an extraordinary friendship that evolved. My father ended up buying his first pair of jeans, and John dressed in a suit and tie in that famous picture holding his green card. He actually dressed them to make sure that the government visually looked like they were separating a family. And the friendship was very strong. To this date, we have the privilege of representing many of Yoko's referrals. And again, John's legacy with the DREAM Act and the Deferred Action, as my father discovered through the Freedom of Information Act, resonates today to millions of students and children. The snapshot of time in the 1970s and my father's contribution to history and the advocacy to turn the light on with media so that the roaches run to the corners, to remind government officials not to use what's prescribed in law for political gain, and to reward a person that dreamed for a better America is what evolved from this. I would urge everybody who was fascinated by this to give not only immigration a chance, but to do your best when you become lawyers, to walk in the footprints of a gentleman like this, to advocate, to represent, and to put your scholarship to help somebody. You never know who will walk into your office, what friendship will evolve, and how you'll contribute to history. That is in the greatest tradition of not only what you're learning as you're in school, but what our founding fathers envisioned. Helping people come to our shores is an extraordinary journey as you help them along, and I hope that you give immigration a chance. Any questions before we disband? Don't be shy. And get the video. Amazon, all of these people have it.
You said before that Yoko was previously married and had a green card through her husband. What happened with that? Why did she have to reapply?
She had lost a green card. A person, permanent resident who has a green card, if he leaves the United States for over a year, loses the residence. During one of the hearings, she had sent me a package of documents, and I found her green card in there under her former name, Yoko Cox. And I must admit that I used it or misused it in a hearing and got myself an adjournment with it, claiming that the government had never shown me her file. She was also an accused in the action, and they should have given me her file and showed me that she had her residence. I guess she had forgotten about it completely, and I couldn't piece it together because she hadn't been in the States for a few years. That's a good question.
Any other questions, anybody? Could be a Beatles question, any? There was some work also done, I think, for George Harrison, who had a waiver problem, and a host of other notable clients through the years, when all of a sudden marijuana appeared in the statute and they had clear convictions of marijuana possession. Joe Cocker and a lot of people who followed in this tradition. No doubt it's an extraordinary case, and I hope I've made the point not only to study the field, but to understand again the evolution of this law and how important it is to be sensitive and cognizant and fluent, if you would, with criminal law, with immigration law, with international practice, and to be trigger happy when it comes to filing claims, whether you're going to an administrative court or to federal court. It's in the greatest tradition of our country, and if you have a client that can afford it, or if you have a client that can't afford it, don't be shy. Litigate. Now, the business immigration class, you know, this is, I think, business immigration on steroids. Because if you have a client like John Lennon, if you have a client who's a rock star, you can probably get an adjudication for a green card very quickly. But nobody should be quelled, nobody should keep their politics down, because it's not the flavor of the day. That's the lesson of this case in advocacy as well. Anyway, one of these days we hope our daughter, his granddaughter, will attend this school or a law school, and that you'll one day be able to stand by your children and convey the same tradition of what you heard this is. Thank you for joining us.